One of the questions we get from time to time is, how do I update or change my will in Georgia? Hi, I'm estate planning and probate attorney Joel Beck with Peach State Wills and Trust in Lawrenceville, Georgia. There's a right way and a wrong way to update your will, and I'll tell you about those in today's short video. So, how do you update or change your will in Georgia? Well, let's talk about the wrong way first. And the wrong way is simple. You take up a pen or pencil and you cross something out and you write something else in. And maybe you initial it or maybe you don't. But in any event, that is the wrong way to go about updating your will, because you see, once you cross out stuff and write something else in, you're obliterating the will. You are taking a step to revoke it, and it's going to invalidate the will, likely the whole thing, maybe only parts, but it's not going to be effective. And the reason for that is because those changes have not been witnessed with the same formalities as when you signed the will in the first place, having it signed and witnessed by two disinterested witnesses, and then hopefully attaching a self-proving affidavit that you and the witnesses and a notary public sign as well. So the wrong way to try to update your will is to attempt to make changes by hand. So what's the right way? You have two options. The first is a codicil. And a codicil simply means it's an amendment to a will. It will be a new sheet of paper. It will explain what is being amended on the other will. And then that codicil must be witnessed as if it were a will itself. It needs to be signed by you and by two witnesses. And ideally, there will be a self-proving affidavit that you and the two witnesses and a notary public sign as well. But there's a risk to this approach of using a codicil. The risk is that the codicil may be lost. It may become detached from the will, and therefore your new wishes are given no effect. Or somebody could make it disappear. Let's say there's somebody who benefits more from the original will without the changes made. They benefit less with the changes, and they make that codicil as if it never existed. They make it disappear. The codicil is given no effect. For that reason, a lot of experienced estate planners are simply not going to do a codicil. What are we going to do? We're going to instead take the better approach, in my view, and that's simply prepare a new will. The new will incorporate your new wishes and replace any prior wills once you sign it. And so the new will, you'll sign in accordance with the law. You'll have it witnessed properly, have a self-proving affidavit, make sure the will is optimized for Georgia law, incorporating all of your current wishes. And then that will be the document to be used as your last will and testament. Using a new will that incorporates your wishes reduces the risk of your wishes not being known and followed because of a codicil that's gotten lost or goes missing. So that's how you update or change your will. Well, when do you need to do that? Well, there's really two reasons that you should update your will. The first one is your wishes have changed. That seems kind of obvious, right? If now you want to do A, B, and C, you need to change your will that does something else to update the will to reflect your wishes. The second reason that you might want to update your will is because the law has changed in some way and it's more favorable to you to update your will. That doesn't happen too often here, but sometimes for wealthier folks dealing with estate tax changes, that might come into play there. But the only reason we're generally going to recommend updating a will is your wishes have changed or the law has changed in some way that it's more favorable to you to update your plan. Now, if you've got more questions about wills and trust, powers of attorney, healthcare directives, I invite you to visit us online at peachstatewills.com. Click on free info at the top and download our guide to estate planning in Georgia. It will give you a wealth of information about estate planning, the types of tools that are commonly used, your options for will plans or trust plans, why you might want to try to avoid probate, and the like. So download that for free, or if you need to talk with an estate planning lawyer, give us a call at 678-344-5342. Thanks.